Now I'm kind of like this.
This is the House Judiciary Committee at its leap day, February 29th, 2024. We have 4 whole bills, starting with 1310, that's Delegate Attar's bill, and you've got everybody up there, so let's hear from you.
Thank you, Mr. Chair, Madam Vice Chair, and members. For the record, I'm Delegate Dahlia Attar, here presenting House Bill 1310, Baltimore City Coordinated Youth Violence Review and Response Team. House Bill 1310 would establish this Youth Review and Response Team consisting of many agencies that are listed in the bill. They're responsible for identifying high-risk youth, analyzing root causes and patterns that lead them to becoming high-risk, provide recommendations that would reduce the amount of high-risk youth, and connect those that are high-risk with the appropriate services. High-risk youth is defined in the bill as the victim of gun violence, a witness to gun violence, or a family member of a victim of gun violence. Currently, state law does not allow for the agencies to share information amongst each other to ensure a team like this can work efficiently and produce positive results. This bill would change that and allow these agencies to share the information confidentially. I ask for a favorable report. Thank you.
All right, good afternoon, Chair Klippinger, Vice Chair Bartlett, members of the committee. My name is Nina Themelis, Director of Government Relations for Mayor Scott, here to testify in support of HB 1310 on behalf of the city administration. The sponsor outlined the purpose of the legislation. We currently have an existing MOU between most of the parties, if not all of the parties identified in the legislation, that allows us to currently, in a short-term fashion, perform much of the work that is outlined in the bill. The need for this work was initially recognized by the city's Child Fatality Review Team. The team recognized insufficient communication between city and state agencies who were supporting children who had died, and in some instances, it is believed that information sharing between agencies could have prevented that child's unfortunate death. We have worked with the Baltimore City Public School System on a series of amendments that would ensure all data privacy assurances and protections are in place while still allowing us to perform this important work. We do have Director Brooks, the Director of the Mayor's Office of Children and Family Success, to outline further details of the review team's work and the purpose of this intensive case management process. For those reasons, we urge a favorable report for House Bill 1310.
Good afternoon, Committee Chair, Committee Vice Chair, Committee members. Again, I am Dr. Deborah Brooks, the Executive Director of the Mayor's Office of Children and Family Success, and I am here to testify in continued support of House Bill 1310. The Baltimore City Coordinated Youth Violence Review and Response Process would be able to provide persistent interagency collaboration, providing wraparound services to youth and their families that are at high risk. These are the youth that have been impacted by gun violence, either them, their victims, their witnesses to gun violence, and their family members. They're providing wraparound services to these youth and their families, which often calls for immediate, ongoing, and multi-layered approach. By allowing us to be able to have this multi-tiered approach with multiple agencies to include both city and state agencies, we can effectively and timely provide these wraparound supports, which would be preventative rather than reactive for many of these high-risk youth. We know that coordinated communication as it relates to our young people is very key and timely to ensure that we do not continue to have an increased number of child fatality youth. This came about after Mayor Brandon M. Scott established a youth violence stat in March of 2023, and we began to see barriers and gaps in the communication across multiple agencies. And so by bringing together these groups of agencies, we were able to develop a MOU, but also knowing that it is important to ensure that this work continues beyond a MOU if there are changes in leadership. And so with that, we are in favor of this legislation, and we ask that you please take this into consideration.
All right, thank you very much. Has the Baltimore City delegation voted on this yet?
No, we're waiting for some amendments that will be voted out tomorrow, hopefully.
All right, what kind of amendments are you looking?
I'll turn to Nina for that.
Go ahead.
Thank you. So there is a series of amendments that would more or less just further identify data privacy protections for the youth and their families. We would also be allowing for police records of a child to be shared with the review team. We would be adding the definitions of de-identified data and personally identifiable data to the legislation itself because those terms are now used within the bill. We would be replacing one of the members of the review team from the Secretary of Human Services or designee to the Baltimore City Department of Social Services or Director's designee. We would be just ensuring that the age range is more closely aligned with the MOU, which is ages 7 through age 21. But about 95% of the amendments are data privacy related that we developed in conjunction with the city school system to ensure that they are aligning and keeping in accordance with all state and federal laws required for data privacy and protection.
Really? The Office of the Public Defender is going to be speaking next virtually, Mr. Zacher, just making sure that we get him moving. And does this, have you had conversations with the Office of the Public Defender, and do these amendments address any concerns they may have?
I have not, and I didn't know they would even be here. No one reached
Okay.
out to me. Have you?
The administration has not either.
All right. Well, we'll hear from Mr. Zacher in a second, but there are other questions for the favorable panel. I just wanted you, it would strike me that perhaps some of the issues that you've identified on data privacy maybe would be issues that the Office of the Public Defender would be caring about a little bit, but we'll find out from them in a moment. Let's hear from Delegate Simmons.
Thank you, Mr. Chair, and thank you, panel, for coming out. So obviously, this is a very important piece of legislation when we look at the needs of what's taking place with our juveniles and our youth. My question to y'all revolves around funding, right? So with so much funding already contributed to Baltimore City when it comes to programs and initiatives geared around the youth initiatives, what will make this different and better compared to what's taking place right now?
So what we are currently doing is actually looking at blended funding from the agencies that are currently part of the MOU. So the state agencies, the city agencies, bringing those resources that we currently have and using it more in a collaborative way, and making sure that we are not duplicating those resources, but using those resources in a timely and effective way to be able to support our families. Also, by being a case management model, to be able to say, coming back and looking at a 30-day, 60-day review to ensure that those services and resources that we put in place are the most effective for those families and for those young people, and making those tweaks where we need to so that we are being responsive fiscally.
Yes, thank you. Delegate Attar, it's always good to see you. Have you had a chance to review the the Maryland Judiciary's letter of information? They have I'm not going to read the whole thing, but particularly they have a question or concern about section proposed local government section 31-11. Particularly at subsection D. So have you had a chance to look at that, or, do you need me to print it out for you, or?
I have not. If you can print it out, that would be great.
That'd be great. I will,
Thank you.
I will make sure that we bring it to your office. And
Thank you.
Ms. Finellis, I think my office on another matter has an outstanding meeting request with you, so if you could get back to us, that'd be great. Thanks.
Absolutely.
Seeing no other questions for this panel, we thank you all very much. We'll go to Mr. Zacher in opposition, please.
Good afternoon to the committee. My name is Jeremy Zacher. I'm an assistant public defender in Baltimore City. I work in our juvenile division, and the Maryland Office of the Public Defender is asking for an unfavorable report on House Bill 1310. I did not have the opportunity to hear the previous panel, so I apologize if anything's duplicative, but it seems like this response team described by the bill, a lot of the efforts within this bill are already being achieved by other sort of agencies within the state. We do have the Baltimore City Mayor's Office of Neighborhood Safety and Engagement. We have the Baltimore City Mayor's Criminal Justice Coordinating Council. We also have the Maryland Commission on Juvenile Justice Reform and Emerging and Best Practices, which is part of another bill that was passed through this committee. So some of the things in this bill seem duplicative. We're mostly concerned about the broad scope and the types of children and youth that will be brought under the umbrella of this bill. Youth is described as basically anyone under the age of 21 who lives in Baltimore City. youth who fall into this category, it would have to be youth at a high risk of becoming a victim of violence, which could include merely being a victim to gun violence, which the bill does not describe gun violence. It does not describe what a witness is. Is it a personal witness? Is it a witness on TV? Is it a video game witness who's watching gun violence in a video game? It can include people who have family members of victim of gun violence. So your second cousin twice removed was a victim of gun violence. You as a youth are suddenly in this category. And it allows them to sweep up a lot of information from government agencies, school records, CPS records, DSS records, DJS records, substance abuse records. All these records would be collected. The youth is never notified that their stuff is being collected under this bill. The parent of the youth is never notified that their information is being collected under this bill. And there's no check and balance. There's no judicial review. There's no way to appeal your position on this list as a youth of high risk of violence. And we just feel like it's rife for abuse. So we're asking for an unfavorable.
Are there questions for this panel? I think I have many questions, but I'm going to take it offline. That then concludes the testimony for House Bill 1310, and thank you very much. I'm now looking, I thought we were going to have to talk to Delegate Sample Hughes. No. Chair of the Dorchester County Delegation is here, Delegate Hutchinson.
Well, good afternoon. I don't plan to take much of your time this afternoon.
Well, that's very nice
thank
of
you.
you.
Thank you, Mr. Chairman, members of the Judiciary Committee, for allowing me to present House Bill 589, Dorchester County applicants polygraph examinations. My name is Delegate Tom Hutchinson, and as you've learned today on the House floor, I am the chair of the mighty Dorchester County delegation. And a sick deer hunter. So this really is a local courtesy bill that will allow Dorchester County to request polygraphs for applicants seeking a position as either a correctional officer in the detention center, a paramedic, or an emergency medical technician. Currently, there are prohibitions of doing polygraph tests as a condition of employment, but there are exemptions for a variety of public service or law protection positions. For example, St. Mary's County already allows polygraph requests for paramedics and medical technicians. Washington County can do polygraphs for correctional officers. Baltimore County, Anne Arundel County, and Frederick County can do polygraph tests for a variety of service positions. I think in total, I counted there's about 12 counties that are able to have an exemption to this prohibition. And with that, I, along with Dorchester County Council, respectfully ask for your favorable vote. Thank you.
Thank you, Delegate. And for the purposes, obviously, we have a lot of young folks here in Judiciary today. Can you just explain to me what a polygraph is used for?
I would have to say that I am not an expert at a polygraph test. So I unfortunately can't answer that question for you today.
Thank you, Mr. Chair. I hate to ask questions on this bill because I'm actually more curious about this policy generally. I see, because, I seem to recall we had something like this from another county maybe in the last year or so. And so it seems like every year folks are adding on to this. But my question is this. I also seem to recall when we put in polygraph requirements for correctional officers in result from some scandal that was going on, that we subsequently had people coming to us asking us to remove them because it was a employment impediment. I can't remember, the exact details of what jurisdiction was having this problem, but has that not come up in discussion, whether the polygraph requirements create, weird problems in hiring?
I have not heard that from my county as an issue that they're concerned about.
Sorry, just a quick follow-up, just for my own personal curiosity. Is there a type of thing you're hoping to screen out?
I am not aware of any issue that has occurred or something's trying to be screened out other than we make sure that we get the best applicants in those roles.
Okay, thank you.
Thank you, Mr. Chair.
Delegate, has there been any recent incidents within your county which would precipitate this?
Not that I'm aware of.
All right, thank you.
Further questions? Seeing none, thank you very much. We're moving very, very fast.
Thank you. Thank
you. And I think we may have, but we may have caught the end of the train here because now we need Delegate McComas. I'll do it for you. Can you, what? Let's just get it going. Or we can go to Delegate Phillips, who just walked in the room. Delegate Phillips, 1307. This is House Bill 1307.
Witness just stepped out. I'm not sure where he went.
All right.
Can I step out just?
Yes, that's fine. Dia Thomas, Kwame Rose. Oh, on the other hand, well, wait a minute. Let's, I just called Delegate Phillips' bill. Do you have your witness?
If you can.
All right, never mind. Never mind. Delegate McComas. Christine Cocciola, do we have? All right. Darlene McLaughlin. Oh, yeah, there you are. Okay, there we go. Delegate McComas, please. You have 3 minutes. Go ahead.
Okay. Thank you, Mr. Chair. Thank you. You are the greatest committee, and I'm not being nice about it, but you are. This is Groundhog Day here because you've heard this bill before, but we think it's important. It's an important issue. So I'm going to say you need to support 1290. You're the committee. You own this bill now, but it needs to have some kind of resolution. And probably Darlene's going to give you what she thinks. So that all this bill has been heard quite a few times in this committee. That does not mean that coercive control is not a serious precursor of more serious power and control tactics by the abuser. I want you to consider that coercive control is abuse and can literally destroy the spirit and soul of an individual. In fact, one can compare it to emotional, social, and spiritual isolation that pulls the victim in a box that gets smaller and smaller as the person becomes a human shell. Over the years, I have seen the House Judiciary Committee deal with some very difficult issues, from the death penalty, juvenile justice reform, gay marriage, malpractice reform, and the burden of proof for domestic violence. Originally, the burden of proof for domestic violence was clear and convincing evidence. For years, the advocates against domestic violence advocated for a lower standard, the civil standard of preponderance of the evidence that the abuse was more likely than not. I am advocating that coercive control is perhaps not as easily identified and might be manipulated by the abuser as opposed to the victim. So I am proposing that for a claim of coercive control, perhaps the burden of proof should be clear and convincing evidence if there are no physical signs of abuse, such as bruises, witnesses, brandishing of weapons, destruction of the victim's property, or harm to a pet or a child. Coercive control takes many forms. There is currently a Massachusetts bill, House Bill number 1547, which has 55 co-sponsors and was filed on 1/18/2023. The bill defines coercive control as a pattern of conduct that has the purpose or effect of substantially restricting an individual's safety or autonomy through intimidation, isolation, implicit or explicit threats, or by compelling compliance. Examples of coercive control, and if you look at there's at least 11 different examples of it, and I'll just, I don't know how much time I've got left, so.
42 seconds.
Oh, okay. Isolation of the other parent from friends, relatives, faith, cultural or linguistic communities, employment, education, or other support networks, repeatedly humiliating or using degrading language or behaviors toward the petitioner, controlling, regulating or monitoring the individual's activities, communications, movements, finances, economic resources, or access to resources, threatening to harm, abduct, or kill individual, a child, or relative of the individual, threatening to punish information or make false reports to police or the authorities, damaging property or household goods, forcing the individual to take part in a criminal activity, committing or threatening to commit cruelty or abuse to animals connected with family, using repeated court actions not warranted by existing law or good faith. So with that, you can read my testimony. We provided a lot of information. I think we need to think outside the box here, and I'm not saying that put coercive control in domestic violence right at this moment, but I'm saying consider a task force, consider a program where we educate people like we do human trafficking or, if someone's suicidal in bathrooms and different places where community, sees things. So with that, I turn it over to my aide, Darlene.
That's great.
Good afternoon, Mr. Chair and honorable delegates. First and foremost, HB 1290 is not about me. I'm a lucky one. I got out. I became a lawyer to show my perpetrator that it could be done and that he didn't have me anymore. This bill is about the victims of domestic violence that remain in the shadows. They have no voices, but we hear you. They have no faces, but we see you. They are constantly navigating a cost-benefit labyrinth of consequences versus escape. They are those that would say that someone has to lead and some have to follow. But leading should not be brutal and without remorse, nor lead to fear of consequences for the victims, their children, extended family members, and pets. Leading should not be homegrown terrorism, and be certain the perpetrators of such ultimate control of their victims are just that, terrorists. There are some that would say that life needs drivers and passengers. I would proffer to you that living in a coercive situation is not living, but surviving, minimizing the pain and suffering, and retreating into a shell that is no longer an individual, but a bondservant to another. If just the presentation of this bill does nothing else, it gives a voice to those who suffer from being totally controlled by someone else's threats, fear tactics, and degradations. In conferring with those who work with victims of domestic violence, it is clear now that the issue has multiple facets that cannot be easily resolved, that indeed the issue may be better addressed by disseminating knowledge, as delegates spoke of, by seeking to provide more outreach tactics such as posters in bathrooms, doctors' offices, and such places as businesses that have public bulletin boards. The pursuit of this legislation has been a renaissance for me. Toward education, empowerment, escape, and outreach, the forms and methodologies yet to be explored. Your time and attention is greatly appreciated. You granted to me here today. Your ideas are welcomed. We must find a way to give victims a voice, an escape, and most importantly, hope. Thank you.
Thank you. Do we have the person virtually? That's my list. Dr. Cocciola? Oh, there we go. There we go.
Hi there. Thank
Go
you so
ahead.
much thank you for taking my testimony.
Sure, go ahead for 2 minutes.
Good afternoon, distinguished members of the Maryland Legislature, victims and survivors and allies. I am here today to urge you to please pass HB 1290, a law that creates protections for victims of abuse, physical and non-physical. Coercive control, now known to be the foundation of virtually all abuse, is an exertion of power and control by one person onto another, oftentimes crossing time and space. It doesn't just happen in the relationship, it happens outside of the relationship. It is time that we look beyond the violent incident model when determining domestic abuse and when we are seeking protections for victims and survivors. Physical violence is not the defining characteristic. Abusers very often use coercion and control in order to intimidate, isolate, gaslight, and manipulate victims. It is intimate terrorism when you do not feel safe in your home and are unable to have agency in your life. Some call it a psychological warfare, like a cult that occurs behind closed doors. Oftentimes, victims do not even know that they are being victimized. It's hard to imagine someone you love, or perhaps someone you share children with, purposefully attempting to undermine you, to strip you of your autonomy. Lest you think this is too dramatic, let me tell you the story of a woman who has been an advocate since the age of 19, supporting victims and survivors, adults and children of abuse her entire career. A woman who has worked in child welfare, is a social worker, a therapist, and an educator on the topic of domestic abuse. Like so many victims of abuse, she did not see her own relational dynamic dynamics as abusive because as a society, we continue to look through the archaic lens of physical violence. Research also affirms that this abuse intensifies post-separation. We tell victims to leave, yet we do not make it safe for them to leave. Or almost as egregious, we do not believe victims, unless, of course, there is physical evidence, and even then we assume that the violence is a one-off incident, when actually the violence is, again, often a last resort to retain control by an abuser, and the coercion and control has been a mainstay of the relationship. It's time to look beyond the violent incident model. It's time for Maryland to pass HB 1290. Victims and their children are waiting to be seen. Thank you.
Thank you. All right, we'll take questions for the panel now. Delegate Grammer.
Thank you. Thank you, Mr. Chair. I don't know if we need a task force because I believe your definition pretty accurately captures what a lot of these victims are experiencing. I just have one question. Can you give us some examples of things you could admit when you're looking for one of these protective orders, pieces of evidence that you're being a victim of coercive control, maybe things that victims might have experienced?
Well, actually, I have a situation right across the street from me. The parents have not seen their daughter for several years now. She got married, and the guy doesn't like the family, says, you've been abused by your family. So her sister's had a baby. She's the oldest child. Her brother graduated from high school. He's now a law enforcement officer. And she has had no contact with this family. And it's very obvious that something's going on because she lives up in Pennsylvania. She even taught school in Harford County, and they haven't seen her for probably 3 or 4 years, if not longer. And I cautioned my neighbor. I said, I think this is a form of domestic violence because she's been separated from everybody that she knew. She graduated in Harford County. So anytime you see where someone is limited in their contacts, they can't keep those same relationships. That's a red flag. And then when they don't have their own money that they can spend. I mean, obviously you don't want the husband or the wife to buy all kinds of stuff, but the point is that they have to kind of ask for permission. And then if they don't, let's say they don't keep the house as clean as Martha Stewart, in other words, there's just, they can't do anything right, and they're just constantly harped on. So those are kind of things you look for. Obviously, you don't necessarily in these kind of situations see bruising and battering because they're smart enough to know not to do that. But they just control everything. And I think there was a book by, I believe it was Charlotte Fetter. Her husband was head of she wrote a book, and I think it wasn't so much the physical abuse, but it was just that emotional abuse that was constantly, you are no good, you can't do anything right, turning the kids against you, threatening to hurt a pet, breaking something that the individual, prized was kind of very important to them. So those are kind of things that, as I said, they don't leave blood, bruising, broken bones, but they crush the soul, and that's very important. And the person doesn't understand that they become so isolated, they don't tell somebody what's going on at home because it's very, it's very personal, it's very private. But the point is, people need to be aware that that's something that happens. And of course, you can extend it to, let's say, a guy that, traffics women, for prostitution or whatever. Same thing, the guy beats the woman up, or he, doesn't leave bruises, but, grabs them and pulls their hair or something. But so it's kind of a continuum, but that can be very painful situation. Do you want to say anything?
If I could address that, Mr. I don't know if everyone knows, but I'm also a litigator. I practice law here in Maryland. One of the things or several of the things that I look for that I can bring in as evidence would be checking accounts that only have the husband's name on it, debit cards that only have the husband's name on it, or spouse. I may not be sexist. Women do this too. So let's be certain of that. But one spouse has control. Where there's neighbors that can see things like the person is not allowed to come outside or go to church. They invite them somewhere, and there's constant, and they see the person getting dragged back in the house. They've seen the evidence of it. Sometimes it's cutting of the tires. I actually had a client whose children cut the tires so mom couldn't go to work, so she lost her job. They cut the wires on her van so the electric wouldn't work. When the tires were repaired, they did something else. There's things that you can do but you have to get the courage, the person has to get the courage to leave. Mrs. Argott out in Washington County got the courage to leave, and it cost Judge Wilkinson his life. So the idea is that control was so pervasive, it went on so long. Judge Wilkinson was compelled to do what he did, but he had no idea what Mr. Argott was capable of and what would happen if he took that control away.
These are things you could.
Dr. Christine would like to.
May I please offer insight? So Dr. Evan Stark was on my committee for my doctoral work, and he wrote the book Course of Control, How Men Entrap Women. Of course, it can happen in the opposite direction, but I think what's really important to understand is it's often very covert and nuanced. And in that, it's really hard even for the most astute of us to miss the signs, but there is harassing behavior. Dr. Stark actually defines it as psychological abuse, gaslighting, manipulation, intimidation, and isolation. He also says it's a control of time and space. He calls it financial abuse, legal abuse, and use of the children as weapons, and sexual abuse. So it permeates all aspects of a relationship in a dynamic way that creates a space where one person has lost autonomy. They have lost agency. He actually calls it perspecticide, where you actually lose your ability to know what you should know. And he has an amazing quote that I think really encompasses what you might be asking. And that is that coercive control is like carpenter ants devouring the foundation of a home. You don't even know it's happening until it's too late. And that's the reality of victims and survivors. I am a survivor. I'm a protective parent. My children were weaponized against me. I was with someone for a very long, extended period of time and did not ever recognize the signs of the abuse. I was teaching on it every single semester in my college courses. I'm a therapist. I work with families. It is so nuanced and insidious. Depending on the characterological traits of the abuser, what we really need to do is shift to looking at not what's going on with the victim, certainly protecting her, but what is this perpetrator setting up to do? They often deny, attack, and reverse victim and offender. These are people who make up stories that they are the victim, when actually we know just in societies, the way society's set up, that men do have more ability to have power and control financially and certainly legally. And when they use the judicial system, they're going right in. As I always say, coercive control, the end result is revenge at all costs. Revenge at all costs. I'm going to take away your home. I'm going to take away your children. I may, in fact, this is when femicide and filicide occur. Coercive control is at the root of 93 to 95% of all femicides in the world. And 35% of women suffer violence in their life, some sort of violence in their life. If 35% of women suffer violence at this rate, how many perpetrators are there?
So it sounds like we have a real hole here as far as domestic abuse goes. All right, thank you so much.
It's a bottomless pit, actually.
Delegate Boucher.
Thank you, Chairman. I get the impression the delegate misses this committee dearly, so thanks for coming back.
Well, kind of do.
Counselor, thanks for recognizing that domestic abuse is not sexist.
It is definitely not.
We have a testimony or written evidence or testimony from the Women's Law Center of Maryland. I want to read to you a statement they made and ask for a solicitation for you to respond. Diluting the protective order with coercive control as a basis for achieving an order of protection may cause more negative perceptions and result in petitions for protection for abuse being denied. This could be disastrous for many who are experiencing real emergent safety issues. How do you respond to that statement by the Women's Law Center?
Is that addressed to me?
You're the attorney, please.
She
Well,
is
you're both
too.
attorneys.
She is too, so
Yes,
let's not
sorry.
diminish her ability. But, I'm just more of a litigator and she's more of a problem solver.
I think you ought to tell him what you had to do to be able to leave the house.
Okay, well, what I did was filed for divorce, but I had to I was literally running for my life. He threatened my life. And
Tell him what he said. He's going to feed you.
Well, we had a farm, and we live in Westminster at the time, and he would say to me things like, if you fall into the hog pen, they won't find anything but your teeth. And if you try to leave me, I will lie about your character and take your children from you. I have 6 children with him. I have 4 boys at the time, 4 boys underage. My daughters were grown. They were learning his tactics. He shoved me down steps backwards. He dislocated my thumbs. And my son leered over me and said to me, "Mom, you should have done what Dad told you to do." Right then and there, I knew I was creating 4 more monsters. If I didn't do something, I was forbidden to go to school. He detached me from my job that I was working just to have health insurance for my children, forced me to quit my job because he was using mental warfare against my sons, telling him that he couldn't come home because I wouldn't quit my job. The whole thing with, yes, if you don't have help, a good litigator can say, look, we don't have enough evidence to use this to put forth in a protective order complaint. But if you have enough, you can. One of the judges said, and we'll go unnamed, that, it will open up the floodgates of too many litigations. But can we turn our back on people that are getting threatened like I was and my sons were becoming, learning to see that behavior? Their mother shoved down steps. I could have broken my body. I had to go to court and get a protective order, and the only reason I got it was because I had bruises on my shoulders from him shoving me, he literally, and I had bruises on my thigh, and they got a doctor to come in and say it was indicative of my testimony, the marks on my body. Not the threats, but the physical violence. That went unnoticed. It was as if he didn't say any of those things. It was as if it wasn't important. But it is important because Mr. Argott made it important. Judge Wilkinson lost his life because of it, because it went on too long and there was no hope for Miss Argott. So she had to file for a divorce. She had to take the ultimate step. She couldn't get an interim separation from him. And he actually proposed, Mr. Argott, saying, hey, they called it a nesting agreement, where we'll live in the same house, you live upstairs and you live downstairs. Luckily, she had counsel that knew that that was the open door for more control, abuse, and threats. My son set my house on fire. My sons opened the door in 21 below zero wind chills in the back of the house and left the door open and told the court I wasn't keeping the house warm. These were all things, he used them as I called them his minions, his tools of disaster, cutting my tires and my wires on my van. I mean, these happened to me, these happened to other clients. These happened to a lot of people, and I'm not hearing, this is not alone. I'm not the only victim, but I was able to get out. So I have to be their voice because they're afraid to talk. They're afraid to come forward. The consequences are enormous. The cost, I mean, I lost my oldest son to this. He didn't talk to me for 7.5 years because his father had won his confidence. Is that what we want for our children and our parents? It took him 7 years to say, Mom, I'm sorry. I want you back in my life. Will you come to my first son's birthday party? And I already had 2 grandchildren with him. This is a painful event. This was not easy. I lost financially. I lost my son, which was the biggest cost. And for years, some of my children didn't talk to me at all, except in passing. My oldest son still only calls me on Mother's Day and my birthday. It is a painful thing to lose a child to that kind of behavior. So coercive control takes on so many facets, and they use every tool at their disposal. They put codes on your phone so you can't call out. I had to get a court order that said I can use the phone to call the children's doctor, my doctor, and 911. 3 phone numbers were programmed into my house phone. I did not have a cell phone back then. That was before cell phones, or at least before I had one. There was so many ways that he attempted to control. I had a private detective following me. They threatened people I associated with at college because I went back to school to try and get away. This is a big problem, and if we can't pass this bill, We have to do something. Put your heads together. You people are brilliant. That's why you're here. Look, and the people you sit next to in church are victims. The people you go to Walmart or Macy's or wherever you shop, they are victims. They're right next to you. The ones that don't talk because they're afraid that their spouse will see them talking to you. My neighbor is a victim. I know he is. He won't look at me and he keeps his head down when he comes out of the house. He is not allowed to talk to me or my son. And we don't want him to have to deal with the consequences. There is so many victims out there. If we can't do anything else for the ones that are suffering physically and mentally and emotionally, we need to do something because we're creating Mr. Argots. We're creating judges becoming victims, or bailiffs, or clerks, or attorneys, the people that represent these people. They take the control, and if they lose it, they take it back in any modicum of way they can figure. And then Mr. Argott's way was to kill the man that took his control away. And I don't think that's what we want for our judges. We certainly don't want it for our men and women that have to raise families in a world where everything is so difficult. So I would love to hear from you all. I'm proposing with some of the domestic violence personnel that I spoke to during this to prepare posters and put them in bathrooms, and maybe we get a funding bill for that next year. I used to talk in forums where teenage girls were in compromising situations, and I would go there and talk about know your partner selection, know what they want in life, know what they want for your kids, know what they want, they're going to allow you to do. I wasn't allowed to go to the Olympics because he didn't want me to go. I was a candidate for the Olympics in my high school years. There's just so many things that we let slip under the rug because there's no voice. Nobody hears them. Nobody chooses to see them. We have to make a choice. We can't just sit by and let it happen anymore.
Are there further questions? All right, thank you very much for coming and testifying.
Thank you for
very
your
much.
time, delegates. Thank you for your question, Delegate Graham.
All right, we have one person testifying in opposition to the bill. Melanie Shapiro, please.
Good afternoon. Thank you, Mr. Chair, Madam Vice Chair, members of the committee. Melanie Shapiro, I'm the Public Policy Director with the Maryland Network Against Domestic Violence. First, I want to be very clear that coercive control is very real, it's very dangerous, it's very scary, and it's very harmful. However, we are in opposition to House Bill 1290 as it would add the definition of coercive control, or a definition of coercive control, to the protective order statute. The protective order is designed to be very narrow in terms of who it protects because the relief available in the protective order is rather extreme, not extreme in a negative way, but somebody can be removed from their house, they can be awarded custody of their children, they can be awarded support, and it should be because those are the situations of life or death. And a lot of the situations that were just described by the survivor that testified before you, she was able to get a protective order. And so threats of harm are eligible for a protective order. False imprisonment, you're eligible for a protective order. The Battered Women's Justice Project did a several years long investigation into coercive control and how it's being added into different state statutes. I have a copy of the report. I'm happy to share it with anybody, but I will read to you one of the summary statements, which says that in light of the risks posed to survivors, particularly those survivors that have been historically marginalized from legal and other systems, by incorporating coercive control language into domestic violence protective orders, statutes, legislators and advocates should show caution because it can have an unintended consequence of having a negative impact on victims and survivors of domestic violence by being manipulated by abusers. And unfortunately, that is the very reality we see today. As you heard the survivor testify, even with physical identifiable bruises, she had difficulty getting a protective order. So we need to ensure that those victims whose lives are in immediate risk can get their protective orders. I am happy to work with Delegate McComas or any of you on language. As she did indicate, there are other states that are pursuing this. I think that information would be very beneficial to receive, how that is playing out and the impact that it is having on victims and survivors of domestic violence in those states. And the language is much more prescriptive. So for all those reasons, we urge an unfavorable report on House Bill 1290.
Thank you, Mr. Chair. Thank you. What are the states that are getting it right? Who's doing it well?
So it's very early in the process. Most of these have come around in the last several years. So Massachusetts, this is the second year it's been introduced. I can look here and see there is a reference to the states that have passed something. Maryland actually incorporated into the rules for mediation a definition of coercive control. And unfortunately, what we hear is that cases are still being not screened out of mediation, even with that definition.
Wow.
So to put it in the protective order statute without those protections in place and without having that education come first, the concern is really how could this have an unintended consequence for victims?
Make it too easy for the perpetrator to use the same code against the victim, right?
Yes.
So far, Massachusetts, you said, is 2 years in. Any other states that are doing it?
Let me see. As of January 2022, Arkansas, California, Connecticut, Hawaii, and Puerto Rico have included coercive control in their domestic violence protective order statutes.
Okay.
So those would be the states that we could look at information and see how it's being implemented, but all of this is relatively new within the last few years.
Okay.
So the recommendation from Battered Women's Justice Project is let's see how it's working. Let's make sure there's education that's happening with the courts beforehand to make sure that it's being implemented properly.
Right.
And potentially use some, they recommend some decision-making tools. That's another conversation.
Yeah.
But there are other things that they say that they recommend would be in place, and to look at how it's being played out in other states.
Okay, thank you.
Thank you.
Yes, Ms. Shapiro, so as I understand it, I just want to make sure I understand your position. Your concern is that doing what Delegate McComas wants would make it more challenging for people or victims of physical abuse or domestic violence. Is that correct? Or
Yeah, so there's a few concerns. One is that it's going to complicate and make it more challenging for victims. It's already challenging for victims who are experiencing physical violence or threats of physical violence to obtain protective orders. And so the second is that the potential harm that can come to victims if this is not implemented properly, educated around properly, that if we just put this definition in the code, it can be used by abusive partners against their victims by them seeking protective orders and manipulating the language and the statute.
Well, you are a zealous advocate for people who have been victims of domestic violence, and we're a better state for it. But doesn't that kind of put, because you're saying it's already hard for people of physical abuse with domestic violence, which are all abhorrent, but I also was deeply troubled what the survivor said. So isn't that saying to victims, well, one type of mistreatment is more worthy than the next? Like, doesn't that put us as a legislators in a difficult position, because we're saying, well, what happened to you, Mrs. So-and-so, is bad, but it could make it harder for victims who also went through another bad thing called domestic violence. So how am I supposed to say whose mistreatment is worse?
Yeah, thank you for that question, Delegate Kaufman. It's not that one is worse than the other. There's one that's a little bit, I think, more identifiable and less easy to manipulate. And the codification of coercive control is happening in different states in different ways. And so I think we have the benefit of taking a step back and learning from these other states and from their processes how we can do it better. So it's not that I don't think that there should necessarily ever be a time, but the question is, should it be in the protective order? Should it be defined somewhere in the family law code? We do have the definition in the Maryland rule, and yet we're still seeing cases with domestic violence not being screened out for mediation in family law cases. And so I don't think we have the systems in place yet for it to be for it to not to potentially have the harm on victims of domestic violence having a coercive control statute being manipulated by their abuser, who quite frankly are experts in power and control dynamics and manipulation.
Is one of the concerns with the way that it's defined, the things that stood out to me is the emotional and the manipulation. And those tend to be sexist biases already that abusers use against. And I can see where this could be used not for victims, but actually for abusers. Is that one of the concerns, is just the language in some ways is using the same sexist language that's been used against women since dawn of time? Is that one of the concerns?
Thank you, Delegate Simpson. I mean, I think, yes, one of the concerns is the language and the definition, and that it doesn't, as indicated, and, Delegate McComas talked about it, Massachusetts has this very specific bill that outlines what coercive control actually looks like, that rises to the level of what a protective order should be eligible for. And those actually, if I recall correctly, changed from last year's bill to this year's bill even. So the work is still being refined. So if we're going to go down this path in Maryland, I think that we need to be very intentional about it, very specific about it, and very deliberate about it. I don't think that HB 1290 gets there, and I appreciate Delegate McComas's offer to have that conversation, and we look forward to doing that in the interim. And also, where in the code does this belong? Should it be in the protective order? Should it be somewhere in family law? Should it be in the rules? Should we be more prescriptive in the rules? But let's not set up a situation where we're just putting language. Coercive control is very, very real, and it's very, very harmful and very, very dangerous. But we also don't want to create that unintended consequence of it being used against a victim, as you indicated as well, based on how it's drafted, could happen. Thank you.
Yeah, thank you, Chair, and thank you, Melanie, for being here, and all the great work you do for the Maryland Network Against Domestic Violence. I guess I'm dealing with some issues in my district with a constituent who doesn't even live with the person who has some coercive control over them, and they're using the kids, like we heard some example. Is there some language that we could work on? And I know you've worked with Delegate McComas in the past, but I don't want it to go another year and another session. If there's something we can do now that we could be specific on some language?
Yeah, I mean, I think that I don't think that Maryland is ready to undertake that addition of coercive control into the protective order this year. I think that we would really benefit from taking a look at these other states and learning from them and seeing what's worked and what hasn't worked. Happy to talk to you offline about the particular constituent and their circumstances, because it's very real. And if there are issues of domestic violence and there is a custody case, then the question becomes, I'd have questions. Did they have to go through mediation? Is there representation? There's other bills that are intended to address some of those other concerns. I think going down the path of adding coercive control to the protective order, I'd like to study more how other states, and like I said, it's really only been, we're in 2024, in 2022 there were like 5 states that have done this, and so I don't think that this is one of those situations where we want to be at the front of the line. I think we want to learn from the experience of other states so that when we do it the right way and we don't harm victims in the process, which I don't think is anybody's intention. And so making sure that we do it the right way and so that what we put into law is sustainable and going to be beneficial for victims and survivors of domestic violence.
Seeing no further questions, thank you very much. That's going to conclude the testimony on House Bill 1290. We go to the last bill, and now in House Bill 1307, and Delegate Phillips, if you'd come up, bring your witnesses, please.
Thank you, Mr. Chair. So that was it's an interesting conversation, and some of the elements of that conversation might even apply to this bill. So, Mr. Chair, Madam Vice Chair, and members of the Judiciary Committee, good afternoon. For the record, I am N. Scott Phillips, delegate for the 10th Legislative District and member of this fine body, Judiciary, the hardest working committee in Annapolis. I know we say that all the time, and it is true. So, the bill before you today was born out of discussions with non-custodial parents. And while this bill is gender neutral, those affected are primarily men. Over the course of a matter of days, shortly after our last legislative session in 2023, I was told of 3 stories of men who were alienated from their children due to the pathological family process known as parental alienation. In these instances, even with custody and visitation orders, these men were denied access to their children. Each sought redress through the legal system, and each dealt with challenges to enforce custody and visitation orders. Their cases languished in a court system that took months to up to a year to redress. As a matter of fact, one scenario is still playing out since last March. Studies have shown that when fathers are not allowed to see the children in a parental dispute, it can have various negative impacts on child well-being. Potential consequences may include emotional distress, challenges to their identities and self-esteem, behavioral issues like acting out, academic performance, relationship difficulties, long-term psychological effects. We understand that the standard is the best interest of the child, but the question, how can it be the best interest of the child to allow these disputes to linger for months while the non-custodial parent is denied access and the child is potentially negatively impacted by the alienation? I recognize the well-intentioned and obvious concerns of those who oppose this legislation. One of the main arguments of the opponents is that it creates a new statute while leaving Family Law Section 9105 in place. If, in fact, having 2 competing statutes with different approaches will be confusing, especially for pro se litigants, I'm open to amendments of offered that will limit the cause of action to times when there is evidence of malicious or intentional disregard of the court's orders. The one issue that is not addressed in Family Law 9105 is swift resolution, which we believe is extremely important. We shouldn't allow these matters to linger. Alienation of parental affection is real. For these reasons, I ask for a favorable report on House Bill 1307, and I'd like for my witness, Mr. Kwame Rose, to just share his experience.
Good afternoon. Thank you to the chair, vice chair, all of the committee members, and Delegate Phillips for introducing this legislation. My name is Kwame Rose, and I'm one of the co-founders of the Foundation for Fathers. We are an organization that helps support fathers have a sustainable relationship with their children around the country. I'm testifying in support of House Bill 1307 because this legislation is about putting a mechanism of accountability in place to ensure that a child has equal access and time with both parents and that a child is not punished by missing the opportunity of bonding time with the aggrieved parent. Currently, Maryland law has loopholes in it that enables the possibility of parental alienation, which ultimately harms the child. The way the law currently works is that if I go through the court system and file for custody and the judge grants me visitation time, the moment I leave that courtroom, there is no entity that can enforce that court order. If the custodial parent decides to keep the child from me, I have to file a motion of contempt, and to get a court date could take upwards of 6 months or 9 months, and in that immediate time, I have no avenue or recourse to see my child. So even if a parent does everything right through the court system, there's no immediate recourse for the non-offending parent or the child. There's overwhelming data to support that joint legal and physical custody is in the best interest of the child, but currently Maryland law allows no immediate recourse, and this bill would address that. By enacting this law, it will not only close the legal loophole that currently exists, but in doing so, it will ensure that children can have a relationship with both parents, that court orders could be followed, that there is punishment that will be put in place for parents who violate a judge's orders, and ultimately it boils down to this. We need support. Maryland law currently lags behind other states, and so if it takes a village to raise a child, then it takes us as a community to support families wholly.
right, thank you very much. Questions for the panel? Delegate Cardin.
Thank you very much, Delegate Phillips, for bringing this bill. I'm not going to talk about the opposition's testimony, but the judiciary basically says they can't do it. They just don't have the capacity to do this. If you put it in place, it would disrupt the ability to look out for the best interest of the child because they would basically be overwhelmed. And if I'm paraphrasing, but that's basically what they say. Do you have any response to that?
So I would respond, if it's in the best interest of the child to have two parents involved in the child's life, then my sense is the court would have to figure out how to adapt. There are approximately 74,000 family matters in the circuit courts for the state of Maryland. That's a lot. It's actually, I think, the largest type of case brought before the circuit court in our state, and that is because we have a number of disputes. As we look at this issue of juvenile justice and we want to reduce recidivism rates and we want to make sure, I think it's important to have parents who are actively engaged in these children's lives. And so I just think it's an important thing for us to figure out how to do. I mean, if the courts are saying we can't do it because we're overwhelmed, but they're saying that their job is to be in the best interest of the child, I don't think those two things come together.
Timeline would be impossible to meet and would interfere with the court system's ability to handle other pending matters, including cases which the child or vulnerable adults' health and safety are at risk, emergency motions, to state foreclosures, evictions, jury trials. Courts are constitutionally mandated to handle all these matters, including matters that require emergency and expedited relief, interests that justice require, particularly that's in the best interest of children, and this would make it that they couldn't do that. That's what they're saying.
I read it. Go ahead.
So Maryland is unique in the sense that when you're in family court in Maryland, before you even get to a judge, there's a magistrate system. And so to say that the judicial process can't handle it, if it's in the best interest of a child, right, currently, if a magistrate or a judge gives an order, not only do we have the obligation as citizens of the law to follow that order, but if someone violates that order, we're simply allowing judges' orders not to be followed, and there is no way to enforce it. The only way we could enforce it is by imposing these penalties, and to say that they would be overwhelmed, ultimately, right now, you have to go months and years before you even get before a judge. Right now, you have to go to the magistrate, who then might send it to a judge, and the judge might send it back down to the magistrate. But I don't think that this would have the overwhelming effect that the opposition or that the judicial is saying, because ultimately what happens when you have these punishments put in place is that at first they might be overwhelmed, but when people start realizing, when offending parents start realizing there are real punishments to violating a judge's orders, then people will stop violating the judge's orders.
Thank you, Mr. Chair, and thank you to the panel. Mr. Rose, speaking specifically to your journey and kind of the struggle that you're going through and so many other folks such as yourself, can you talk about a little bit more about the process between filing for custody and obtaining custody or joint custody of a child? What happens in that space?
Thank you, Delegate Simmons. So my personal story is my daughter is 6 years old. Her mother alienated me from the time she was born up until when she filed for custody when my daughter was about 18 months. It took me 4.5 years, 14 court orders that she violated before she was ever held in contempt, before I was ever given, and ultimately what wound up happening was that I was awarded full custody. But during that process, when she filed, I was given, you start off very intermediate. So I had to go and drive and pick my daughter up every Saturday morning at 6 a.m., drop her off at 6 p.m., do the same thing on Sundays. When she violated, they gave me another day, but I didn't have overnights at that point. I then had enough, mind you, I have no criminal record. I'm an activist. I do great things for the community, but I had to start off without even being trusted to be a father. So even though I followed the court order to a T, she would withhold the child for any reason she got upset. I would have to call the police. The police would come to tell me, I ultimately learned that they couldn't do anything. And the irony is like me calling the police. But I would have to call the police. They would show up and say, hey, you have to take this to court. You have to file a contempt motion. We can't enforce this, even though I had a court order, even though it said I was supposed to have my child at this time. And so then I would file a motion for contempt. I would have to then wait 6 months, 9 months. Ultimately, even after I went with the court order in place, I went another 18 months collectively over the last 6 years without seeing my child. And it was all baseless accusations. Not one time was I ever found in contempt. Not one time did I ever miss a child support payment. Not one time did anything happen. It was just this legal loophole that as soon as we left the courtroom, no one could enforce this order. And it wasn't, when I say it wasn't until the 14th time that she was only found in contempt $200, which if I'm paying $1,200 in child support, that could easily cover that. But it wasn't, there was no way or no route or any way for me to get my child. She could not take my child to school and hide the child from me. Because then the way the law works in Maryland is that if you go so long without seeing your child or the custody order not being followed, you then have to regress and start that the slow process of working up to 50-50 custody again. And so I've seen this, and I've told my story publicly, and that's why, we started the Foundation for Fathers last year, because so many fathers have to suffer in silence because this has done so much. Because there's also the part where, they have to still pay child support even if the custody order is not being followed. And so many fathers were reaching out, not only in Maryland, but around the country, was saying, I did the right thing. I went to court. I got the court order. I pay for the motions. I pay for whatever classes they told me to take. I literally just want to be an equal parent in my child's life. But the moment we step outside of court, no one can enforce the order. I have to wait months before I get back before a judge. And then also, by the time you get back in front of the judge 6-9 months later, he's forgotten about your case, or they have forgotten about your case. So you then have to relitigate. Then think about how much the attorney fees cost. That's another reason why we started this, was because we realized it was happening on every socioeconomic level for non-custodial parents. We have prominent attorneys who are being alienated from their children. But when I was sitting in court, I was listening to the stories of fathers who couldn't afford to be there. They literally could not afford to have a lawyer that could advocate for themselves. And I just happen to have a big mouth, and I like advocating. And so I said, man, there's a way we can help these people out. And then although it started as fathers' rights groups, it's really about equal parental rights, because women started reaching out and saying like, hey, my child's father is doing, exactly what y'all are saying is happening to you all. And so we've been going around the country and trying to make it equitable, right? Because if two parents could get along, they wouldn't be in court. And that's what it boils down to. And we need the court. Unfortunately, we need the courts to intervene, to have some type of immediate recourse, because the only person that suffers when a court order is in violation, or the main person, is the child. And that child loses their relationship, that child's confidence becomes shattered, that child starts wondering, well, why is this parent not coming to get me? And they're being told whatever from the offending parent, but they don't know the reality. And that child's innocence is literally just to have a relationship with both parents. And because there is no immediate recourse or mechanism to get in front of a judge immediately, right now, that child suffers. Their confidence, their grades, their ability wholeheartedly, that child is just put in a disadvantage. And studies have shown that children who succeed have both parents, children have more of a chance to succeed with both parents being in their lives as much as possible. And so we as the Foundation for Fathers, we're not advocating to take children from the mothers. No, we're advocating for joint 50-50 custody. And I know in Maryland, the presumption of joint custody doesn't exist. and that's where Maryland lacks behind in the country as it comes to progressive equal rights. But, you know, I went through it, and there was nothing I could do but sit, get frustrated, collect a police report, file a motion for contempt, and pray that there was an empty space on a docket sooner rather than later.
So just so we can wrap this up a little bit, I'm just going to say this is what happens when you're in the barbershop.
I have a follow-up, though. Yes, please. Yeah, thanks. So can you draw down on the physical toll, the financial toll that these type of cases took on you specifically?
Yes. So when this first began, I was working in the mayor's office of Baltimore, making, I think, like $60,000. Because of the way, and I know it's a separate issue, but because of the way the calculations work, a custodial parent is allowed to make up whatever cost they claim for the child without any proof. And it's based off of my income. So I was paying $1,200 a month off of a $60,000 salary. They don't take into account your bills. So I wound up actually losing my house. My friend who made me come stay with her is sitting in the audience. And I wouldn't have had custody if I didn't have that support system. But then also the attorney fees. I paid over $45,000 in attorney fees. And all my attorney could tell me was, we just have to follow the process. And eventually I realized, you know, I went to college on a full scholarship for debate. I have attorneys who are friends who are attorneys. I can learn the statutes myself and advocate for myself. But after paying that and still having a child support obligation while my child was being kept from me, because I was still obligated, even though I was being alienated, my child's mother was still collecting that money. And if I didn't pay it, then I lose my license, then I lose my ability to drive, which was a mandatory requirement for work. Then maybe I'm incarcerated, which then I could lose my job. And so it adds up. And it takes a toll. And so when you think about the fathers who can't advocate for themselves or don't have the confidence or the public speaking skills that I just luckily encountered throughout life, or having both parents in my life, I watch fathers in court get frustrated, and then ultimately, because they don't know how to express themselves and can't afford an attorney, they ultimately wind up just saying, forget it, I'll see my kid when they're 18. And that harms the child because of the financial obligation on the non-custodial parent. Again, because the legislation does not take into account the bill. So I had my daughter 14 to 16 days a month, which was essentially 3 days short of 50-50 custody, but I was still obligated to pay $1,200 a month. Out of that $1,200, you know how much money came back to me when my daughter was with me to pay for food, for her clothing? $0. And so it virtually makes it impossible. We have fathers who we work with now who have every other weekend, but because of their child support obligation, they can't get their child every other weekend because they have to work their second or third job. And there's no recourse. And so what we do is our goal is by the end of the year to help provide legal services for the fathers or parents who can't afford it. Because look, had I known better, I'd have stayed in college and became a family law attorney, because I'm telling you, they're making bank. And ultimately, it becomes impossible financially for fathers to continue to fight.
Thank you, Mr. Chair. Mr. Rose, thanks for sharing this with us. I was an alienated father myself, had filed numerous petitions of contempt, and even after the custodial parent was found in contempt, nothing was done to that individual, and it exacerbated and got worse. How would this bill address putting some teeth into that so that the person who's found in contempt would be forced to the table and have the visitation rights fulfilled?
So it does a couple of things. One is it speeds up the process, right? So it's a requirement that you get in court faster. The second is that it would place a dollar penalty associated with the contempt, right? The third is it would say that from a time perspective, if you force me to lose this time, then I get that time back, right? And so I know there are some advocates who don't like the concept. Some of that is already in 9105, but this would provide some additional clarity to the judiciary on how to apply basically those penalties.
And if you look at the states who have been ranked the highest for equal parental rights, such as like Delaware or Alaska or Arizona, they have these same punishments or repercussions inside of their legislation.
Thank you, Mr. Chair. Thank you, Delegate Phillips, for bringing this bill. One of the things that your witness just mentioned was the presumption of joint custody. And I just wanted to just kind of visit with you for a minute about that. Do you think if the state of Maryland actually did have a statute regarding the presumption of joint custody that your situation would have been different?
I do. There are a couple of supporters and some of my co-founders here in the audience. One happens to be a law enforcement officer who is going through it as well. But yes, ultimately, because what it does is it creates a timeline or an avenue for 50-50 custody. And right now in the state of Maryland, that just doesn't exist. And so a lot of what you see is a lot of fathers just ultimately defaulting to every other weekend. But I do think if there was a presumption of joint custody, that it would not have taken me 4.5, 5 years to gain 50-50 custody.
Thank you.
No.
No, she had an emergency for work and couldn't make it.
She was on the list. All right. Delegate Conaway.
It's one of these things I just can't help myself. When you talk about punishing the child's parent, that's a little rough when you think about it. If you think about you gave, as I guess you could say as a male, you gave someone the gift of seed of life, and now you're very upset with them, and you're contemplating sending your child's parent to jail. I mean, even if they don't go along with the judge's order, do we have any barbershop conversations about that?
We're not trying to send any parent to jail.
No. As a man, I know what I'm doing when I file some paperwork, and then I would say, wait a minute, maybe I need to step back off of this for a minute. I understand I want it to be 50-50. I understand I want to have input, but now this is really going in a different direction, because even if I get the 50-50 joint custody and then send the child's parent to court or whatever, what happens when the child turns 18 and finds out all of this went on? I mean, there's a certain offset there that I'm just asking that you might want to think about.
Well, if you look at the legislation, some of the things that are offered that are don't involve jail or fines are things like parenting classes or co-parenting classes, which would be beneficial. Because I can tell you from experience, half of the issues that we have is just not being able to have an adult conversation with the other parent. But
Opinion, I've been in a position too, and sometimes when you take your position, the other person might not be able to have an adult conversation with you. You might feel that way. That might be valid. But again, to take the high road, that's your child's other parent. All I was asking is, did you ever consider that when you thinking about all these legal moves?
yes, and I consider it. I am wholeheartedly against jail as an entity, period, personally. But what this is intended to do is, if a person is continuously violating the law, ultimately there are consequences for that, and that's all the attention was.
Respectfully, thank you so very much for responding to me. I just wanted to give you my input, and I'm sort of in disagreement with you, but it might take some time, as I understood it back in my day, for it to soak in. So thank you very much.
Thank you.
Thank you, Delegate.
All right, seeing no further questions for this panel, we thank you very much. And we'll go now to Michelle Smith in opposition.
Chair, Madam Vice Chair. I'm Michelle Smith on behalf of the Maryland State Bar Association Family Law Section. I am here testifying in opposition of the bill you've just heard about, HB 1307. I've listened very carefully to the testimony, especially of Mr. Rose, and I certainly empathize with him and wish I had been his attorney. However, HB 1307 is, we urge an unfavorable report because this is already the law, basically. We have a statute that you've heard about already, Section 9105, which pertains to this particular circumstance. I note that Mr. Rose didn't indicate that he filed a petition under that statute, that he simply used the contempt remedy. Perhaps it would have been a different outcome if he had done that. In addition, we already have the ability to file for a modification of custody in which all of, hopefully, our new factors would be considered by the judge to decide what is in the child's best interest in the modification. With that said, I just wanted to highlight some of the detail that in response to questions or comments. One thing that's wrong when you look at the statute in Section 9109A in the legislation, the bill's language is a little unclear. I note that there was an issue of maybe this could clarify things for the judge. It's unclear what it means when the parent fails to comply. Is that 10 minutes late to drop off, or is that withholding for 3 years? We don't know. In addition, the judiciary doesn't like it because it puts all kinds of constraints on the judges. They shall do the things in Section B, such as provide parenting time that's convenient for the petitioner. I have no idea what that means, or at the expense of the non-compliant parent. So for those reasons, we urge an unfavorable report on House Bill 1307.
Delegate Simmons.
Thank you, Mr. Chair. Thank you, Mr. Chair, and thank you for coming. There was a little bit of testimony about the caseload pertaining around that. Can you talk a little bit about that and what's taking place in that space to mitigate it?
Yes, if I understand your question, maybe I'll answer it in two parts. One, just taking the testimony that was offered by the delegate when he indicated, and I don't know if this number is correct, but I assume it is, 74,000 family law cases. There are a lot of family law cases, some of which are extremely urgent. Children are being physically harmed and they need immediate attention on custody matters. Those are the cases that get expedited hearings. The opposition from judiciary, I think, is warranted. That if we allow a 10-minute late to drop off petition to bump a child who's being, burned by cigarettes by their parent and needs an immediate custody, emergency custody petition from the other parent, we're going to be in a sad state of affairs. So I do think the opposition from judiciary is warranted. If you're asking me about the process, I could speak to that. Was that more your question?
Yeah, you can go with it.
Okay. So right now, if, for example, what happened to Mr. Rose happened, he could file a petition for relief under Section 9105. He would not get a 10-day hearing. And I'd like to say that I don't even know, as a really good lawyer myself, I don't know how I would prepare a custody case in 10 days. The thought scares me. So I don't know that that makes sense. But he would file that petition, and depending on, I understand he may have been in Baltimore City. I could be wrong about that. But depending on the jurisdiction, he would get a notice of hearing. He could also file for a modification of custody, asking that the custody be flipped like it eventually was for him, so that he would have sole physical custody. And that modification would be heard in the normal course. He could also file a petition for contempt. And petitions for contempt are heard on a more expedited, it's not actually expedited, but on a more expedited basis. In Anne Arundel County, for example, I would get a show cause with a hearing date within 2 months, probably, on a petition for contempt. And if I were his lawyer, I would advise him to file all three things so that he would get the court's attention in a variety of different ways and that he could get his case moved in a more expeditious manner. If there were allegations that the court was not going to school, the child was not being taken to school so as to avoid him being able to pick up his child, which is what some parents do, I would put that prominently in my pleadings so that the court knew that the child was not attending school. And there's even petitions that can be filed if the child's not attending school. DSS could be informed if the child's being kept home from school, because it's not legal to keep your children home from school for unwarranted reasons. So I would suggest it would be a sort of all hands on deck, all petitions that are available to him, all three that I've described, including maybe getting DSS involved, so that he could get the court's attention and sort of separate his case out from the run-of-the-mill case where there's no exigency.
Thank you. Can you talk a little bit, so obviously with the testimony offered here today, and I think a little lag of, can you talk about the racial disparities that's taking place in that space when it comes to court decisions with parents, and what are you seeing as a prosecutor and a veteran in that field?
Well, I think if you're asking me as a prosecutor, that you'd be asking me about criminal cases. That's okay, but which I could comment on, but I don't think it's relevant. And if you're asking me about family law, I myself don't see racial disparities. I'm sure they are there.
How long have you been working in that
Family law
field?
attorney, 8 years now.
And you don't see it?
I don't see it, no.
Okay. All right, nothing further.
Which I'm glad to report.
That's fine.
But
Thank you.
I'm sure there's something out there,
I appreciate it.
particular cases.
Oh, I'm still formulating my question. Thank you, Mr. Chair.
Thank you, Mr. Chair. I guess I'm still forming a, I don't know, your testimony right now is a little frustrating.
Okay.
And I know I heard the delegate say that it was a barbershop conversation. Well, I can attest that it's a beauty shop conversation as well. And I'm saying this from this perspective. There is a racial disparity issue. I'm sorry you don't see that, but I hope that you dig a little bit deeper. Have there been an assessment, or is there an assessment on the mental harm that is happening to the children who are caught in the middle? I know we talked about, or you spoke about, the physical harm. We need to rush to that. Yes, ma'am, we do need to rush to that. But we also need to rush to the fact that there's mental harm that is happening as well. Is there ever an assessment done to that extent in your position?
Yes. There's custody evaluators that do that assessment. And they are both provided by the court and privately. There's therapists that testify regarding that issue in courts all the time regarding custody. I'm not disputing that there's potentially mental harm to children who are being unjustifiably denied time with their other parent. I'm certainly not an advocate of doing that. I'm strongly against it. But we already have a statute, multiple statutes that cover it. And so this statute is just unnecessary and provides handcuffs to the court that is just not going to be in the children's best interest.
The next part I'll ask you is, do you, in your opinion, and in your profession working with all these different agencies, and you referenced DSS, do you believe that they're overwhelmed also?
In what regard?
With these types of cases, because you referenced that DSS should have been or could have been notified if the child wasn't going to school, and other examples that you utilize. Are you of the opinion, of the mindset, is that agency overwhelmed also?
I don't have any personal knowledge of whether they're overwhelmed.
But you use them as an entity that the parent should reach out to?
Sure, they're a resource. If the child is being harmed, DSS is a resource, absolutely.
Thank you.
Thank you, Mr. Chair. I appreciate Delegate Phillips for bringing this bill. As you can see, I'm a number 2 on it, so I truly support this. And I know a lot of men, a lot of friends with this issue, and so that's the problem. So the question I wanted to ask you is, and I know some of these answers, but I would like for you just to indulge me, and so that individuals that are listening can hear. What is the process for filing a modification, and how much do you think the attorney cost is for that?
I couldn't predict what other people charge.
I'm not asking you to predict what other people charge. I'm asking you to guesstimate what you think the attorney cost would be to file, to do the process, to file a petition. My apologies. What do you think the attorney cost would be to file a petition? Because you have consistently referenced, they can file a petition. So in your professional opinion as an attorney, what do you think the cost would be for someone to file a petition in court?
What kind of petition? The complaint for modification?
Any of the petitions that you mentioned, how much you think it take for them to go to court?
I'm
That's
sorry,
my point
Delegate,
I'm
I
making.
really could not predict
But it's a
that.
cost, right?
Sure.
Absolutely. And so, the gentleman mentioned that if you're making $60,000 and you're paying child support, do you not, I'm trying to understand if you are processing the cost it take for a parent to have the ability to see their child and to go through that court process. I'm trying to understand if the Bar Association that is opposing this bill, do they understand what it takes for a gentleman or even a lady or whoever is dealing with this issue to go through the court process, the cost of attorney fees?
Yes, and we already, in our law, provide for the court to be able to award attorney's fees. It's
To whom?
already there.
They award attorney fees?
On a modification of custody, sure.
That is if you are successful.
No, in any circumstance. I mean, I doubt a court would award fees if you're not successful, but the provision is already there in our law.
Okay. So I do agree with Delegate Sample Hughes that I believe this disproportionately impact men of color, even those of lower economic status who cannot afford attorney fees. Is there a way that these fees well, let me ask you this. Is there pro bono service?
Yes.
For this, of individuals, say that gentleman, that same exact issue, there are pro bono services?
Yes, there's pro bono services in the state of Maryland. There are also, I think, in most of the courts, there is free legal advice. In fact, I do it for several courts.
No, I was asking pro bono service, not free legal advice, meaning they would not charge any fee to go to court to file a modification. There are pro bono services. People will go to court like they would, okay. I've never heard of anyone going to court for free for a civil matter other than like rent control and stuff like that, but I
Yes,
haven't.
and you can attain that information, either pro bono or low bono lists from for example, from the Anne Arundel County Bar Association. We have a long list of services that
Somebody would go to
attorneys
court
are.
for someone for free
Yes,
for this
yes,
matter?
ma'am.
Okay. The gentleman is saying no. And
gentleman?
so I will stop for now, Mr. Chair. Thank you.
So I believe one of the things I heard you say, Attorney Smith, is that, and it almost sounded like at a minimum, you're talking about 2 months, right? If I were to do a contempt proceeding and I were to file under 9105. Is that fair?
Well,
At a-
contempt would be different. It's 3 different avenues, but
Okay.
yes, I think, 2 months would be the fastest, probably.
The fastest,
Unless a child was being harmed.
right, unless the child.
Physically, in imminent
So-
danger.
So the idea of a child being harmed, and we're relying strictly on physical harm, does not, let me finish, does not address the emotional harm that I think the gentleman discussed. It does not address the time period for parental alienation. And so I'm going to ask you, what would your recommendation be, considering that we do have 9105? How would we speed up this process to improve the ability for a non-custodial parent to, because you do this work a lot, I used to, I haven't done it in a long time, but how would you speed up this process? Let me hear from you.
Yeah.
So that a non-custodial parent would not be alienated. And not only speed it up, but hopefully not have them spend $45,000.
Those are all very laudable goals, and I'm with you on that. I wish we could speed up the process. I think yeah, you have the power. I think realistically, the best way to do it would be to work with the judiciary to come up with some language that they will allow and support. I think 10 days is too fast. We were successful last session in getting through a bill that talked about an expedited hearing when parents relocate, and, sorry to have my back to you guys, relocate and against a court order. And that was something that I worked with, yes, exactly. Previously delegate, now senator. So it's possible if we had the right language. The other issue that perennially I've discussed with people such as yourself, legislators, is that, and let me just explain for a moment, there are in each county, in most of the counties, they have what's called a DCM protocol. So they have their own internal memo about how they're going to set cases, okay? And there is a very specific section usually regarding family law matters. And there is a definition in each of those DCM lists about how and why they're going to set expedited family law matters. If we could have a piece of legislation that unified that for the entire state of Maryland so that there would be one set of criteria that everybody played by, that would be a fabulous thing with regard to family law matters. And that could be a place where you would put this type of information. And it would be as simple as saying, if there is an allegation of an unjustified denial of parenting time, access, whatever you want to call it. I don't prefer visitation because that's a little pejorative. But if you could put that into a DCM across the state of Maryland, then all of the courts, all the practitioners and all of the pro se litigants would know what they had, the burden they had to meet in order to get a quick hearing. So those would be some of my suggestions, and I'm happy to work with you and try to craft something for a later time.
And I appreciate that. How about this idea of just the pure cost? After we've gotten an order, court has issued an order, right? It is not often that a judge turns to the custodial parent and says, you're going to pay for these legal fees, particularly what I would call at the lower socioeconomic end of the business, right?
Right.
So how do we address the cost associated with someone, and probably may not make too much to qualify for pro bono, but not enough to afford the legal expenses? What would your recommendation be on that? I'm sorry, Mr. Chair, but I'm trying to get the expert to help me out here.
I believe the law already provides the mechanism for that, as I answered to Delegate Tolles, but perhaps you're asking us somewhat.
In practice, right? I mean, in theory, but not necessarily in practice.
Okay, well, first let me start by saying, if 9109 was to pass, this would be just another, it would be the fourth avenue.
And I understand. You know, we don't, unfortunately, we don't necessarily draft our own legislation. Legislative Service put it in that way, and when I saw your note, I realized, I'm like, why didn't they just figure out how to modify 9105?
Yes.
But anyway, that's a whole different story.
So this would cause, if the non-custodial parent was going to hire an attorney, they'd have to hire an attorney for all the avenues, right? And then they would ask for attorney's fees. But even if they're self-represented, they could still ask for attorney's fees. 9109, as written here in your bill, does say things like, at the expense of the non-compliant parent, they're going to have the additional time. And it says things like, assume the financial responsibility of ensuring that the visitation schedule is maintained if the parents live more than 20 miles from each other. I assume you're talking about transportation costs there. It's not clear. It's not 100% clear. Those, and the court may award attorney's fees. Those things are already allowed under our law. In fact, transportation costs, if the parents live far apart from each other, are already a line item on the child support guidelines and
Okay.
should be considered anyway. And they would be considered if there was a modification in the sense that one parent had moved away and was denying for that reason, and that transportation costs had to be levied against that parent. That could be done through the guidelines. The courts have that power already.
Okay. All right, that's it for me, Mr. Chair.
I'm sure there'll be further conversations offline. In all likelihood, Delegate Williams, please, then Cardin.
Yes, thank you, Mr. Chair. And I guess I just want to piggyback on some of the questions that Delegate Tolles and Delegate Phillips were asking. And I don't know if, I felt like I got what Delegate Tolles was trying to ask, but I don't know if the answer came forth. We were talking about two things. You mentioned 9-105 and the petition to file under that particular statute of the family law article. You also mentioned a motion to modify custody. And I think what we're trying to get at is under the current system, not with this bill, under the current system, what is the average timeline it takes from soups to nuts to complete that process? Is it a month? Is it 2 months? Is it 10 months? Like, what is the general time frame in your experience, your professional experience?
Of course, it depends on the variables of whether the parents are going to cooperate with each other and settle, or whether they're going to have litigation. So I would say 9 months would be an average amount of time.
Okay, and the guys are shaking their head agreeing, roughly.
I'm sorry, I didn't hear you.
That's okay. It wasn't really a question, it was just me acknowledging
Okay.
something. So roughly about 9 months. And during that 9-month period, I just want to make sure I understand this completely correctly. During that 9-month period, the non-custodial parent has to continue to pay child support, even though they are putting forth an allegation that the custodial parent is basically violating the previous order. That's correct?
From a strictly legal standpoint, if there's a court order ordering the non-custodial parent to pay child support, the non-custodial parent has to comply.
Okay. And even though they haven't seen their child, this process is going to take at least 9 months.
Well, the court can make up for that on the backside when there's a modification, or when there's a contempt, or when there was a granting of the petition for denial, or I forgot, really, you guys should know there's another avenue, which is a motion to enforce the order. So if you have any outcomes of those 4 particular pleadings, the court can order that the child support that should have been not paid, if I'm saying that correctly, be recouped.
Okay, so say it's been a year that the person has not seen their child, because they've been trying to work this out amicably amongst themselves. And then they file this motion, and it is litigious, and it takes 9 months. So now we're talking a year and 9 months that they have not seen this child. And you're talking about recouping it on the back end. So does that mean that they're going to get an additional 19 months, or my math is off, this is why I'm an attorney.
I understand what you mean, yeah. Don't make me do
21
air
months,
math.
sorry. 21 months of additional, return of their child support?
They can ask for an adjustment, yes.
But is that always granted?
Certainly not.
Okay.
It depends on the facts. Every one of these circumstances depends on the facts of the case in the best interest of the child.
Okay,
I mean, we're
so-
just talking in hypotheticals here.
We are talking in
Yeah.
hypotheticals. This judiciary, we have a tendency to do
Yes.
that from time to time.
We have to. I recognize that.
Because I'm trying to just paint a picture of the concerns that brought forth this bill to begin with. And I think that's why this bill was brought forth, because of the frustration of the system, of the family court system, the frustration about the presumptions that currently exist in the law, the frustrations about the timeframes in which it takes individuals to have to deal with this. And most lay individuals are not like you and I, Ms. Smith, where they're attorneys or they have that background. They just want to go on with their lives. And to have to pay $45,000 for most individuals is something that would prevent someone from even taking the time to file in the first place, and will just simply turn around and say, F it, I'm just not going to see my kids because I can't afford the legal fees I need to fight this situation to see my kids. Now you have children growing up without the other parent in their lives. And what is the mental trauma, back to my other colleague's point, when those things occur?
I sympathize with all of that. I've represented people at lower cost who are in that circumstance. I sympathize with it all.
I was just trying to get a sense of the timeframes in these situations. Thank you so much, Ms. Smith. I really appreciate your expertise.
Thank you.
Chair, I have just one question. That is, when you have a client on this side that we're talking about here, is there any mechanism to enforce the order? Is there any mechanism to enforce the order or to get the custodial parent to actually adhere to what they're required to do? Or you just have to keep on filing papers until a judge takes away their money or whatever, or takes away their child support, or takes away their, I mean, I'm not sure. What is it that we can do to enforce it? Can you send a sheriff out to pick up the child and bring him to the?
No, not unless you have a court order. There are circumstances where that can happen because there's a court order to do that. But the mechanisms are the ones I've already described, the 4 different things,
Right.
pleadings that can be filed.
And then once you get those orders filed and they still don't adhere to it, what happens?
The court deals with them at the hearings, the particular
I
hearings on
understand,
the
but
pleadings.
is any of it enforceable? And I guess eventually they just take the child away from the custodial parent? Is that
Right.
That's
That's
the
what
end?
happened to Mr. Rose, and that's what should happen.
So
Yeah.
there's just no way, going back to Delegate Williams' questions, you just have to put up with this for 2 years,
Yep.
pay the prices of all the fees, because there's no, if the custodial parent is going to fight it, there's just no way to do it faster. There's just,
Well, I never agreed that there was 2 years to be waiting. In her example, the person waited a year before even filing, and so it was a year and 9 months. I don't know why the person would wait a year. So if you file quickly and you get into court, that's the way our system works.
Okay.
And that's how it should work. That's due process for both parents. That's the best interest of the children as the standard. That's enough sufficient time to actually prepare a case so that the facts can be determined in a proper manner in our system.
Thank you. Thank you.
Okay, thank you very much. This is not going longer than a minute. Go ahead, Delegate Tolles.
Yes, sir, thank you. I don't want a response. I just want to say for the record, I did get.
No, if it's not a question, is it a question?
Yes, it's
Give
a
us
question. Yes, it's a question. I just want to say for, I will briefly ask you, I got some information that says that if you make over $60,000, then you would qualify for free pro bono services because you fall into the large middle class. Is that true?
I have no idea.
Okay, well, that's what I got from free legal services. Thank you.
Thank
I don't
you.
want to say which one, but.
Okay,
Thank you.
thank you.
That concludes the testimony on House Bill 1307. Thank you very much. We're going to switch to a voting session in a second, but for now, we're going to go off. One moment. We have one person to introduce. Delegate Kaufman, please.
I know that debate has gone long, but I want to just introduce an amazing young man, a freshman at Towson University. Zaid is joining me as my shadow today, so thank you.
Now we are adjourned with the bill hearings.